Hello and welcome to Jordan's webinar. My name is Mark Craig and I'm Associate Director here at Jordan's. This webinar is the first in a series provided free to our clients and partners. It can be set against your continuous professional development requirements. It will be recorded and will be available to download from our website in due course. I am joined today by my colleague Simon Bates. Simon is Executive Director, Solicitor, Commercial at Jordan's Corporate Law.
Morning, everybody.
Our webinar today will highlight the key terms of GDPR. We will talk about the steps that organisations should take to comply with GDPR, and we'll offer some thoughts and quick fixes towards compliance with the new regulation. Due to the large number of attendees on the call today, you've all been muted for the duration of the webinar. However, as this is designed to be an interactive event, I'd be grateful if you could email me with any questions throughout the session. My email address is mark_craig@jordans.co.uk. Any questions we don't manage to get through today will be answered by email after the event. So without any further ado, let's begin today's webinar.
Thanks, Mark. As Mark's already said, the purpose today is to tell you a bit about GDPR. I'm going to divide our talk into various parts. We're going to look at the basics of GDPR and then talk through some practical examples of its impact. We'll conclude by telling you a bit about how Jordan's can help. As Mark's already said, at the end we can take some email questions, and those we don't have the time to deal with on this webinar we'll respond to later on by email. So what is GDPR? Well, it's brand new data protection law, and it completely replaces the existing data protection legislation. The reason we've got it or the formal reason, is to enable the harmonisation of data protection laws across the European Union. At the moment, the UK is quite neutral with regards to data protection law within the European Union. Germany, for example, is much more strict, and GDPR is moving much more towards the German model rather than the current UK model. It comes into effect on the 25th of May this year, so there isn't much time for organisations to get ready for it now. The real headline is that if you breach GDPR, you are likely to suffer much more heavy fines. For example, the maximum fine for non-compliance is 20 million euros or 4% of turnover, whichever is the higher.
I think we talked this the other day. That's so £1 billion turnover business. That fine is 40 million euros. Is that right?
Yes, that's right, Mark.
Sorry, a billion euro turnover, big pardon.
That's exactly right. So if you compare that with the current maximum fine in the UK for breach of current data protection legislation, that's only £500,000. So what this means is that organisations are going to have to take data protection compliance much more seriously going forward to avoid the risk of these much greater fines. There's also going to be commercial pressures that businesses are going to face to comply. You may already find, particularly if you are a data processor, you are receiving lots of requests asking whether you are in fact GDPR compliant. I'll talk about this later on as to why organisations are getting those types of commercial pressures. One final point just to mention on the introduction here is that Brexit is going to have no impact on the application of GDPR in the UK. When GDPR comes in, the UK government is also introducing legislation at the same time to say that GDPR will continue to apply to the UK even when the UK leaves the European Union. So in simple terms, what does GDPR cover? Well, it's the law about how an organisation collects, uses and stores personal data. So if GDPR covers the law about how an organisation is handling personal data, What do we exactly mean by personal data? Because I think this is often overlooked and people don't always understand. The strict legal definition is that personal data means information relating to an identified or an identifiable natural person. But what does that mean in practical terms? Well, let's look at some basic examples. Your bank account and how much you have in your bank account and your bank account details, that's personal data. Your HR records, that's personal data. What you've ordered from Amazon, that's personal data. Where you live, your address, that's personal data about you. Even your business email address can be personal data. For example, my email address is sbates@jordanscorporatelaw.com. That identifies me, Simon Bates, as working at Jordan's Corporate Law. So that is personal data about me. Anything you put in your contact details and things like Outlook, so if you are putting names and addresses of contacts, even if they're business-to-business contacts, those individuals that you're putting into your Outlook contacts, you're putting their name, address, where they work, their mobile number, maybe their landline number, maybe their date of birth, sometimes their spouse name, sometimes their children's names, sometimes even their dog's name. All that is personal data about that individual. Emails that you send, I mean, I'm sure most of us have done this from time to time, that sends an email on a work email address to a colleague, slagging off another colleague, and that, when you slag somebody off, that's personal data about the person you've just slagged off. So, as we'll see shortly, those individuals who have been slagged off can get details of that personal data from your employer in due course. So, in my mind, it's impossible to think of a business, or indeed a not-for-profit organisation, that does not hold some amount of personal data. It's also just worth bearing in mind that personal data doesn't just relate to electronically stored data, it applies to manual records as well. So, for example, most HR records are not stored online, but they're kept in a filing cabinet, and they are still personal data. So it doesn't just relate to electronically stored stuff.
Right, Simon, by manual records, you also mean, obviously, paper filing systems, isn't that right?
Yeah, so any sort of paper filing system is going to be personal data. In fact, the only way you can really get around that is by if you have a room and you just throw all your paper into that room, so that if you need to find records about somebody, you have to literally search through all those bits of paper. So in practical terms, almost every single manual record going to be personal data. So let's just look at some of the ways in which GDPR will affect organisations. And we're going to go through some quite simple examples, but I think this helps illustrate the broad scope of GDPR. And what we'll see here, it's not just about IT and techie stuff like that, far from it. As I've already said, it governs how an organisation collects, uses and stores personal data, and it provides a set of rules around that. So let's just go through some of these rules in basic terms. The first one is that an organisation has to tell an individual the purpose for which that organisation is gathering that individual's personal data. So let's give you an example I think we've probably all come across. When you go shopping these days and you go into a clothes shop, invariably when you go up to the checkout to pay, they say to you, "Can I have your email address so I can send you the receipt?" Well, that's actually a blatant breach of GDPR, because the real reason they're gathering your email address is not to send you the receipt. The real reason is because they want to send you marketing. So they should be telling you that that is the purpose for which they're gathering the personal data. So that type of practice is going to have to stop. Another example is websites have to tell you what they intend to do with your personal data. So if you go to almost every website, you'll see on the home page a small link at the bottom of the home page, which is to a privacy policy, and that privacy policy is where the website is meant to tell you what it's going to do with the personal data it collects from you when you visit that website. Now, interestingly, there was some research by the Information Commissioner's Office, which is the body responsible for for data protection enforcement in the UK, and it did some research in the autumn, and this was under the existing data protection law, and it looked at the privacy policies of 30 or so leading retail websites. And it actually found that a staggering 26 out of those 30 websites have non-compliant privacy policies. That's non-compliant with the current data protection law. So if retailers can't comply with the current law, what hope do actually most have of complying with GDPR? I mean, one of the things that the Information Commissioner's Office has said is that GDPR is not a revolution, but it's an evolution. But for most organisations, certainly in my experience, because they are actually not compliant with existing data protection laws, actually GDPR becomes much more of a revolution rather than the evolution that the ICO is saying. I think that research just illustrates the point. The next one we've got here is that subject to certain exceptions, an organisation can only process, that means do anything with, personal data with your consent. Now, I say there are some exceptions. One of the exceptions being, for example, you can process most HR data without the individual's consent. But the rules around getting consent have changed. So under GDPR, consent has to be freely given, specific and informed. Now again, if you look at websites, you'll see on many websites that there are tick boxes whereby organisations are getting consent. Although fair to say that some organisations don't even use tick boxes. But tick boxes is a very good way of showing you've got consent. But things are changing on that, so you won't be able to have, you can't have a pre-tick box. So you often see that sometimes it says, I consent to receiving marketing literature, and the box is already ticked, and you have to physically untick it. That is not giving freely given consent, so you won't be able to have pre-tick boxes. Another thing you can't have is you won't be able to give a sort of generic consent. So again, I think we've all seen it on websites, something which says a tick box along the lines of I consent to my personal information being passed to trusted third parties. Well, what is a trusted third party? That's not clear at all. That's not a specific consent. So organisations are going to have to be much more detailed. So instead of saying trusted third parties, they might say, we might pass your details on to a bank or to an insurance company. But just having something very generic like trusted third parties is not going to be sufficient. There are also going to be a whole new set of rules under GDPR about how you get consent from children. A good example of how both these first two sets of rules has caused a problem is in respect of the pub chain Wetherspoons, and they have taken actually quite a much publicised decision to delete their entire marketing database because they didn't know actually where they had got much of their marketing details from. So, for example, you went into Wetherspoons pub, there'd often be a competition on one of the bar tables, and it would say, you know, answer this question, send us your email address, and you could win, you know, a couple of pints of beer or whatever it happened to be.
My email address is in that, definitely.
I think mine is probably too as well. But they weren't telling you that they were going to use it for marketing purposes. They might have also had a jar on the bar in which that you could put your business card in, but again, they weren't telling you what they were using it for. So they've decided that they weren't telling you the purpose for which they were gathering that data, and they certainly haven't got consent. So actually, they've made a decision to say we're actually now deleting our entire marketing database going forward. Now, to be fair to Wetherspoon, probably email marketing is not their main form of marketing, but it just goes to show the type of problems that organisations are actually facing. The next one is that personal data has to be adequate, relevant and limited for the purpose for which it has been collected. That sounds a bit legal, but what does that mean in practice? Well, again, I'll give you an example. If you go and book a flight with EasyJet these days, you are asked for, when you're booking that flight, one of the questions you're asked is for your age. And when you go to the drop-down menu there are only two options. One of the options is you're under 18, and the other option is you are 18 or over. Now, EasyJet have a legitimate reason for asking that particular question. That is, they need to understand whether you are an unaccompanied minor or not. If you'd gone to that website previously, you would have seen that they asked that age, and they, instead of just giving those two options, they gave you a number of options, which was, I'm under 18, I'm 18 to 24, I'm 25 to 34, I'm 35 to 44, etc. Now, they've had to change that because actually, when you're booking a flight, there was no good reason to know what age group you fitted into, not for the purpose of booking a flight. They needed to know whether you're 18 or whether you're under 18 or not. That was a legitimate purpose, and therefore, that's a very good example of how very simple things like asking someone's age is going to have to change for many organisations. The next one is that personal data has to be accurate and kept up to date. And that's an obligation on the organisation to do that. So, for example, HR teams are going to have to perhaps check more regularly with their employees about whether they're holding the correct home address, whether they've got the correct contact details in the event of emergency. So things like that. So you can expect to get more of those types of annoying emails asking you to confirm whether the personal data an organisation holds about you is accurate and up to date.
We actually had a question from a COSAC client about how frequent they should keep that up to date. Is there any views on that?
I think that, we're going to talk about that in this next section, that a lot of what GDPR is about, it doesn't set out specific time periods, and it's up to an organisation to set its own time periods, but it has to come up with a reasonably justifiable reason as to why it's setting that particular time period. So let's just talk about that next, because we've seen here that the next one is that personal data can't be kept any longer than is necessary. So this is about how long do you keep the personal data about your ex-employees? How long do you keep contact details in a CRM system after that person's not been in touch with you for some time?
CRM being client relationship management.
Yes. So any sort of shall I say, I perhaps use the marketing database going forward.
Yes,
so as you rightly say, Mark, we're often asked, how long are we allowed to hold personal data under the law? Well, the simple answer to that, there isn't a time limit. Your business determines what is the necessary period for it, but you've got to be able to justify that choice. So let's just take an example of HR records. An organisation might determine that when an employee leaves, it should keep that employee's payroll details for, say, 6 years, because that's the length of time that HMRC can come back on an investigation. So you might want to keep those payroll records for that period of time. But let's look at other HR records. Your employees left. How long should you keep details about their sickness? Why should you be keeping that for 6 years? You might determine that perhaps you should keep that for 2 years because you might get requests for references, etc. But you might have a different period for different parts of your HR records. The real point here is that businesses need to determine their policy, their retention policy, before they face investigation from the ICO rather than after they face that investigation. The important thing is here that they determine their own policy and they've got a reason for their actual policy. And one of the things we'll see in a moment is that GDPR actually requires organisations not just to comply, but to demonstrate their compliance. So let's look at some more examples of what GDPR covers. Well, this next one is this is actually one of the techie ones, but it's not all about tech. So organisations have to implement appropriate technical and organisational measures to ensure that personal data is kept safe. That means doing things like making sure your IT system is secure. It includes basic things like making sure devices that might be used have passwords on, etc. But it's not just, even this one's not just about techie stuff. It includes things like ensuring that visitors who visit your building can't see the personal data that might be held within your building. It's ensuring that staff are trained so they don't disclose personal data. The next one here is one that is a surprise to lots of organisations and one that lots fall foul of. And that is that organisations cannot transfer personal data outside the European Union, even if it is intra-group. So what that in simple terms means is that if you've got a EU or a UK subsidiary, technically it is not possible for it to transfer personal data to its US parent company. Now, there are some exceptions to this. So transfers are allowed to certain countries. There's only a handful of those. I think there's about 8 or 10 in total. They include countries like Switzerland and Argentina, and even the Faroe Islands, but oddly, not the USA. So if you want to transfer personal data to the USA, you have to find another method. Now, there are ways around it when it comes to the USA, for example. So in the USA, an organisation can sign up to something called Privacy Shield in the USA, and the EU will allow personal data to be transferred to organisations that have signed up to Privacy Shield. They can also put in place something called binding corporate rules. To be honest, I've yet to come across an organisation that uses binding corporate rules. The reason they don't is because that process takes a long time. It can take about 9 months to put in place binding corporate rules because they have to be approved by, in the UK, the Information Commissioner's Office. The common way around it is to make sure that you have a contract in place with the organisation, even if it's intra-group, to whom you are transferring the personal data in the USA, and you have a binding contract in place that incorporates a set of model terms that have been approved by the European Union. And that's the method that most organisations use to enable them to transfer personal data from the European Union to outside the European Union.
So Simon, we've got loads of clients at Jordan's who have a UK subsidiary and an overseas parent, US or Hong Kong or Australia, for example. They're all in that non-EU space. Are they covered by this as well? Are they caught by this?
They are caught by this, and I say for all those organisations, the simplest way around this is to put in place an intra-group agreement. It's a bit of a paper exercise, I'll admit that, but it's put in place an intra-group agreement which contains the clauses that are specified by the European Union, the model clauses, and that's obviously something we can help these organisations with. But just to look again at just further on about this whole idea of transferring data outside the European Union. On lots of occasions, organisations aren't aware they're transferring personal data outside the European Union. I mean, we recently did an audit for a client on its GDPR compliance, and they had a CRM database, a marketing database, and obviously that was full of personal data, and they were using a cloud-based system to store their marketing data on this cloud-based marketing database. And what we discovered was that actually that the servers for that marketing database were actually in Asia. So they were actually transferring personal data, although they were sat on a PC in the UK typing this information away, they're actually, unbeknown to them, transferring personal data outside the European Union. Now again, that's something we were able to put a workaround on, but that again was, it's the sort of thing that organisations fall foul of without being aware. Following on from that, organisations are only allowed to use data processors which provide sufficient guarantees that they're going to implement appropriate technical measures to ensure that personal data is kept secure, and who are going to comply with GDPR. One of the things here is to understand, I think, what a data processor is. I mean, a data processor is someone who processes personal data on the instructions of somebody else. Again, we've used this term processing. It sounds technical, but it isn't. It's just the word that GDPR uses to mean doing anything with or performing any operation in relation to personal data. So it can mean storing personal data, handling personal data, transmitting personal data. So typical examples of data processors include an organisation providing payroll services, they're a data processor. An organisation who provides hosting services, they're storing personal data. An organisation that provides a cloud-based CRM system, marketing database, they're again holding personal data, albeit in the cloud. They are a data processor. Anybody providing onboarding or outsourced onboarding services, again, they are a data processor. So there are lots and lots of organisations that are data processors. The problem for a customer or client for data processor is that under GDPR, that customer or client can only engage a data processor who provides sufficient guarantees that they are going to comply with GDPR. So that's one of the reasons why, if you are a data processor, you are going to start to get lots of questionnaires about your GDPR compliance, because your clients and your customers, particularly if they are large clients or customers, are not going to contract with you unless you are providing sufficient guarantees as to your GDPR compliance. So you are going to see a lot more, and also if you're engaging a data processor, you are going to be under an obligation to carry out some degree of due diligence on that data processor to make sure that they are complying with GDPR. This then leads on to your contract with your data processor, because under GDPR, the contract between an organisation and their data processors has to contain a set of mandatory terms. They're not mandatory clauses, they're mandatory terms So in other words, you must address, and it's about a dozen or so issues in your contract. And if you don't, again, both the data controller and the data processor there will be in breach of GDPR. So this means that certainly if you're a data processor, you are going to have to make sure that you revise your standard terms of business to make sure that they contain all the necessary mandatory terms. Otherwise, you are going to find that your clients, particularly your large clients who are GDPR savvy, will not engage or will not contract with you going forward because you are not entering into contracts that contain the mandatory GDPR terms.
This is relevant, obviously, for Jordan's as well, where we're looking at the letters of engagement, so it's useful. Thank you.
Yeah, that's right, and that's something that obviously we're undergoing at the moment to make sure that going forward, all our terms of business and our contracts are GDPR compliant. Some more examples of the GDPR rules. There is this requirement now to demonstrate compliance with GDPR. So what this means is that actually you can, if you comply with GDPR by accident, then actually technically you can still get fined because you're actually unable to demonstrate compliance. I mean, quite frankly, I find that a little bit ridiculous. But there is a serious side to this. I mean, it does mean that organisations, have to do things like implement measures such as staff training on GDPR. And particularly if you're an organisation that employs more than 250 people, there are some quite stringent record-keeping obligations that you will have to comply with under GDPR as well. The next one is that individuals have a right to access their personal data. So this means that organisations have to be very careful about what they say or record or allow to be recorded about individuals. As I've already said, you get these emails that go between individuals within an organisation slapping off a colleague.
Never.
That's personal data. And it can be very embarrassing if you get a subject access request. Now, this has always been the position, even under the old data protection legislation. But what has changed here is that under the old law, an individual, if they wanted to gain access to their personal data, they could be charged a fee. It was a fairly nominal fee of £10, but it was sufficient to put people off. So you can see that there's going to be a lot more of these requests because under the new law there is no fee. And secondly, organisations used to have, I think, 40 days to respond. Now they're only going to have a month to respond to these subject access requests. GDPR also provides, in certain circumstances, for the compulsory appointment of a data protection officer. Now, this is one of the areas where there has been a bit of a myth under GDPR because organisations have all thought they've had to appoint a data protection officer. That's not true. The only requirement to appoint a data protection officer is if you are carrying out large-scale data processing of what we call special categories of data. So that's quite sensitive personal data. And you've got to be processing it on a large scale. So a good example of a type of organisation that will have to appoint a data protection officer will be a hospital, for example. But for most organisations, there will not be a requirement to appoint a data protection officer because they're not carrying out large-scale data processing of special categories of personal data. Now, that's not to say that the organisation shouldn't have somebody who's responsible for looking after data protection, but there's no compulsory obligation to appoint a data protection officer for most organisations. Another set of new rules relates to data impact assessments. So there are a complicated set of rules which are going to apply mainly to tech companies. So if they are going to be involved in new technologies, they are under an obligation to carry out a formal assessment of the impact that that new technology is going to have on individuals and their personal rights. So, and they'll have to make a formal record of this. But for most organisations, it's not going to apply. But if you are a tech company, this is something you are going to have to be very aware of going forward. So who needs to be concerned about GDPR? And is there any sort of exemption from GDPR for small businesses? As I've already said, I think from the examples I've already discussed, I can't think of any UK company that will not be affected by GDPR in some way. I mean, everyone's got employees or are sending or receiving emails, so they're all going to have, so that's all going to have some GDPR consequence. I've said almost. I'm sure some clever person will come up with an example of a UK company to which GDPR does not apply, but but for almost every business, GDPR will apply. There is no exemption for small companies. I've heard this said on a number of occasions that if your organisation employs less than 250 people, GDPR does not apply. That is a complete and utter urban myth. The only significance of the 250 employee rules is that some of the more detailed record-keeping requirements under GDPR does not apply to businesses employing less than 250 employees. But GDPR will, in the main, apply right across the board, whether you're employing one employee or 1,000 employees. I've tried throughout this also to keep referring to organisations rather than businesses or companies. This is because GDPR also applies to not-for-profit organisations as well as businesses. It applies to any organisation that's established in the EU, so it doesn't just apply to the UK. It also, unbelievably, has an extraterritorial effect in that it also applies to organisations that are established outside the EU if they are selling goods or services to individuals in the EU. So, for an example, a business established in the USA, but which is selling online to individuals in the European Union, and the sales are directed to those individuals in the European Union, that organisation in the USA must comply with GDPR. It also applies to non-EU established organisations who, and to quote from GDPR, monitor the behaviour of individuals in the EU. So that's basically providing online tracking. Well, if you think about that, most websites these days use cookies that track the behaviour of individuals. So you could say that almost just about all non-EU businesses are caught by GDPR. Now, I'm sure that can't have been the intention, but at the moment, that's what the wording actually says. So if you are an organisation outside the EU, but you are caught by GDPR, you have, as well as complying with GDPR, you have an additional obligation, which is to actually formally appoint a representative in the EU, and that representative is then your named contact for all data protection issues in the EU, and actually can be liable for your breaches of GDPR as well as you.
Is there anything Jordans can do about that, Simon?
So what we're doing here is we are suggesting to organisations who are outside the EU is that actually they form their own representative in the EU, so a subsidiary company, so that subsidiary company can act as its representative in the EU. So there's been nothing under GDPR, which prevents the appointment, self-appointment of your own representative. And so the best way of doing that is to create a separate subsidiary.
Okay, thank you.
So what can Jordans do to help clients with their GDPR compliance? The sort of thing we're doing with clients at the moment is actually working on a number of sort of specific projects. So clients often ask us to help with their GDPR in sort of discrete areas. So that might be doing things like making sure that they're getting the correct consent for their data processing. It might be rewriting their privacy policy for their website. It might be amending their data processing agreements to make sure they contain the mandatory clauses. It might be putting in place these data transfer agreements to allow them to transfer personal data outside the European Union. The really big job that we help organisations with, however, is to carry out an audit or a gap analysis to ascertain where they are not GDPR compliant. So here we work with clients to understand exactly what personal data they're holding. And that's a real challenge for a lot of organisations. They actually don't appreciate the extent to which they are holding personal data. So we find out what personal data they're holding, where they've got it from, what they intend to do from it. And from that we're able to provide a report to the client telling them what steps they need to take to make them GDPR compliant, where they're not already GDPR compliant. And in fact, most organisations we come across, they've got a lot of steps to take to get themselves into a position where they are GDPR compliant. One of the questions that we are frequently asked is, well, is there a quick fix? I was asked this the other day when someone said, can we just send me a policy to make us GDPR compliant? Well, a couple of answers to that. It's not just about policies, right? And we've seen there's lots of other examples where you need to get yourself GDPR compliant. And secondly, it's not a standard fix. What each organisation does with its personal data is unique to that organisation. So it isn't just a case of filling in a form somewhere or other. But let's be honest. If for a lot of organisations, if they've not started to get themselves GDPR compliant now, then it's going to be extremely difficult to get themselves sorted by the 25th of May. So what we're saying, we are actually saying to a lot of organisations who we feel that they've got an awful lot to do and are not going to have the time which to do it, is to actually concentrate at this point in time on getting their public-facing documents correct and GDPR compliant. So, for example, make sure that what goes on your website is GDPR compliant. You've got the correct consent. You've got a GDPR compliant privacy policy. Or if you are a data processor, your data processing agreements are GDPR compliant with all the requisite terms. So if you haven't got that, your big clients are not going to do business with you after the 25th of May. I've just put a link on there to our website. There's a whole load of more information on our website about GDPR and the steps that we can take to help businesses comply. But I think that, in essence, sort of wraps it up from my end. So have we got any questions, Mark?
Thank you, Simon. I guess just firstly, we do have a question. Firstly, though, if anyone has any questions, please email them to me. My email address is on screen there. It's mark_Craig@jordans.co.uk. We do have a question in from Andrew already, who's on the line. He says, I'm a small manufacturer who supplies a local wholesaler. I have no employees other than myself and only one business who I supply. I don't think I need to apply for GDPR. I think his question is whether he's correct or not. No, I'm not.
Right. Oh, there's a couple of things there. First of all, I knew there'd be some clever so-and-so who tried to come up with an example of a business that didn't need to be GDPR compliant. And the second thing the second thing which I'll start with is there isn't such a thing as applying for GDPR. There's no sort of registration or licensing application to make. You either have you have to get yourself compliant, and there's no sort of formal registration process there. The second point there is in that particular example. I'm sure that they will be collecting that organisation, that business, even though it's a one-man band, will be collecting personal data. It is likely to be storing somewhere contact details for its single wholesaler customer. Even if it's just contact, even though they're business-to-business contact details, there will be names and addresses of individuals and personal data about those individuals. Likewise, they will have suppliers. They're almost certainly collecting personal data in respect of contacts within their suppliers. Now, I do admit that that the steps they're going to have to take to be compliant are probably quite small. But, they will have to, for example, put in place technical and organisational measures to make sure, even to business operating from one single laptop, to make sure that personal data, albeit it's not very much, is secure on that laptop. Now, that's not a big thing for an organisation to do, but it does have a GDPR, a small GDPR impact.
I think there's another point of if he has a supply chain relating to his manufacturer, he doesn't specify what his manufacturer under doesn't say. But I guess it's if he has anyone who supplied him, not just who he supplies.
Yeah, all those contact details.
Yeah, fine. We do have a question through which Robert asks. I was wondering what your advice would be regarding checking the identity of persons making a data subject request. And would you believe that the month-long deadline to respond would only start once the identity has been confirmed?
That's an interesting one. You obviously have to be satisfied. I can't actually tell you when that deadline actually starts running from. But I mean, if you are, the point about this is if you start deliberately using delaying tactics, you are going to get into trouble. So. I think it would be. I think if there are good reasons for you not being able to comply within the 30-day time period, I think there are provisions under GDPR to allow you to seek an extension if there is a legitimate reason. So if one of the legitimate reasons is that you haven't got identity, but you're right, you do need to make sure. It would be a breach of GDPR itself to actually pass the data onto the wrong person.
Would it be fair that the processor or where you're being asked for this information, you should go back to them as soon as you can for confirmation of their identity if that's the problem?
Yes, I think that's the issue. You can't deliberately delay.
Yeah, I think that's what the point is there. Okay, other question we have about the slides. Yes, the slides will be, Stephen, available after the event. We're going to put them on as a recording on the website that you have on screen, which is the About Training and Events website, which I'm just highlighting just now. Also got a question from another Andrew, actually. This one's Andy. Do emails with clients with personal data need to be encrypted under GDPR? And I know that this is one of the definitions within one of the articles.
It's quite a difficult one to answer. The reason it's a difficult one to answer is because you have to take appropriate technical and organisational measures, and what is appropriate for each. What is appropriate depends upon how much personal data you're handling, and actually the size of your organisation, in the sense that what would be reasonable for that organisation to implement. One of the other areas of difficulty here at the moment is that the ICO is meant to be issuing a set of guidance about what they consider to be appropriate technical and organisational measures. We are now less than 3 months from the time that GDPR goes live, And certainly when I visited the ICO's website yesterday, they had not yet issued that particular guidance. So that is not helpful for organisations at all.
The clock is ticking.
Yeah, the clock is ticking. So if you go to the ICO website, what they are currently doing is directing you to some quite old guidance on there, which says this is what you should be doing. And the best I think an organisation can do is actually look at what is currently on the ICO website, because I don't see how the ICO can actually start finding organisations when they themselves have not got their act together. And I think so long as you are compliant with their current guidance, and that is the best thing to do. I mean, one of the things just to stress about GDPR, and it's the same with the current data protection legislation, it's not about getting to the 25th of May and going, phew, we're up to date, 25th of May, we don't have to worry about this going forward. What we found with the current data protection legislation is that every few months, the ICO is issuing more and more, is issuing guidance, and it will continue to issue guidance under GDPR. So GDPR will evolve, and so organisations are going to have to keep up to date with the later guidance that the ICO issues from time to time. So, my view is it's about getting the very basics right by the 25th of May, and then evolving over the next, as GDPR evolves, to evolve with it.
There was one of the blogs, might have been in the summer, from the ICO, which I read, which it was kind of, I'll paraphrase rather word for word, but what I took away from it was the ICO were relatively comfortable as long as you're showing willingness. And that's sort of typical regulatory stance, which is that if you're showing willingness, you've got a timetable for improvement, you've got an action plan, you've got resources. You might not be compliant today, but there was a suggestion that they weren't going to come down hard, at least initially, as long as you have that kind of intention.
I think that's exactly right, Mark. And I think again, this is difficult for organisations because the ICO has issued. It has stated as a policy decision rather than a legal decision, a policy decision to say, look, we're not going to come down hard on organisations that are trying to comply. And there's very good policy reasons for that, because look, there are going to be lots of organisations who don't try to comply, and they're the ones who should be being hammered. So it's unfair on the organisations who are trying to comply that they get hammered too. So I think what we will find is that, hey, this is a policy, and so it's informal, it's not binding, it's not the law, but organisations that are trying to comply and are taking steps to comply, even if they're not compliant on the 25th of May, but have a programme for compliance, I don't think the ICO is going to come down hard on those organisations. Where they will hit hard and where they will want to make examples is of those organisations who just say, do you know what, we've always ignored data protection, we've never gone to trouble before, and we're going to continue to ignore it.
There's certain telephone and broadband providers that I'm thinking of that I probably shouldn't mention, but they're in that sort of space, I suggest. I do have another question from Sarah. Part of it I'll ask. I guess it relates to what we're talking about, which is that the clock is ticking, which is there a typical time scale for an audit? Length of rope as usual.
Yeah, question. I know. Yeah, I'm trying hard to avoid giving illegal answers. That won't know the non-committal answer. Look, but it really does depend upon the size of the organisation. And the really hard bit of it, I have to say, is the bit that you as a client have to do, which is actually, we ask you to complete and we give you guidance on sort of things we're expecting to see, but it's to complete this data map. So we ask a series of questions because it's about ascertaining what personal data you're actually holding. And that's quite difficult for a lot of organisations. There tends to be not one person who has a handle on what personal data they have. So you have to ask, various departments. You might ask your HR department, you might ask your marketing department, you might ask your operations team, all these different questions about what personal data you've got. Once we know what personal data you've got, we can then ask a series of supplemental questions to ascertain what you're doing with it. So we can get that done once we've got the data mapped within 2 or 3 weeks, and come up with a gap analysis where you're not GDPR compliant, and we make recommendations of what you need to do to get yourself GDPR compliant from that gap analysis. But the difficult job, and I say we do help organisations give guidance. We know what we're expecting to see with most organisations. The difficult job is actually gathering that what personal data they're holding, because we find that they're holding loads more personal data than they actually think they are.
I think a lot of businesses do, where when they start asking their employees what actually data they've got, it usually turns into a rabbit hole.
Yep.
We've got loads of questions to do, which is great, but we've probably only got time for maybe 1 or 2 more. There's a supplemental question here from Andy. Could client sign a client sign a mandate agreeing what data can be kept for as long as the company wants? I guess the point, I might be reading this correctly. I guess, can you sign terms and conditions that don't specify how long data should be kept?
My view is probably no, you can't. And the reason I say that is because the question of consent relates to we talked about consent. That's about you processing data full stop. So obviously you need consent there. The other point is it is a separate part of GDPR which says that data cannot be kept any longer than is necessary. I think the answer to be is if you did do that, what you would try and do is run a defence which says that this person agreed that the personal data could be kept for this length of time, and therefore agreed that that was an appropriate length of time. The problem is that GDPR is not, ultimately it's enforced by the ICO. I mean, individuals do have rights to bring their own personal actions, but in reality what happens is that the individual complains to the ICO, and the ICO then investigates and says you are not compliant. So it ceases to be a contractual issue.
Okay, so we've probably run out of time, and I want to respect everyone's time for spending the time on this call this morning. Thank you very much. Thank you for attending. We hope you find it useful. Any questions that we received that we didn't get time to get through will be answered by email. And we've made a recording of today's session, which will be made available on our website. So if you or your colleagues want to listen again, it will be available. Please keep an eye out for future webinars. They'll be advertised either by email to you, or they'll be available on the link that I've got on screen. And until the next time, thank you and goodbye.
Thank you. Bye.